In today's workplace, things are evolving quickly and complexity is the norm, but clarity is a choice. This Week at Work is where leaders get practical solutions and timely insights for today's toughest workplace challenges.
Hello, everyone. I'm Phil Brandt, President and CEO of AIM Employers Association. Welcome back to another episode of This Week at Work. Comp time sounds like a simple, employee-friendly benefit, but for many employers, it's actually one of the most misunderstood and legally risky practices in the workplace. Today, we'll separate fact from fiction and explain what every HR professional and business leader needs to know before offering time off instead of overtime pay. As usual, I am joined by my friend and co-host, Burt Garland, shareholder with Ogletree Deacons. Burt, welcome back to the program today. How are you?
I'm doing well. Thanks, Phil. I appreciate that. It's a great day for a podcast, and this is one of those topics we've never talked about on the show, but certainly when we're out and about talking with clients or your members, we inevitably get questions about comp time. And so I think this is a good one for us to discuss in more detail.
I agree. And this is one I know that people get wrong. And sometimes they're not aware of why or how they're getting it wrong. So it's a good episode to tune into. And if you have follow-up questions afterwards, by all means, reach out to Bert or myself, and we'll be able to give you some guidance. But this one has some serious risk to it. Before we get going on comp time, Bert, how about a little segment of Lawyer on the Clock?
You got it, Phil. Let's dig right into it.
All right, let's go. Pull that lever. Lawyer, you are on the clock.
Thank you. So let's talk first about what the EEOC did just on July 21, which was just over a week ago. They voted, not surprisingly, 2-1 on party lines to issue a notice of proposed rulemaking. Get ready for some applause. To eliminate the long-standing requirements for employers and other covered entities to file annual aggregate workforce demographic reports by race, ethnicity, and sex. Yes, I am talking about the EEO1 reports, also the EEO2 through EEO6 reports. The commission argued that the reports are inconsistent with Title VII's colorblind principles, something we've talked about often on the program, that you're supposed to make employment-related decisions without regard to protected categories. May also raise constitutional concerns and imposes a heavy cost on business. They're not narrowly tailored or necessary for enforcement. And so this notice of proposed rulemaking was set for Federal Register publication the next day, and then there's a 30-day comment period and the public hearing that's been scheduled for August 11. No, I want to make it very clear, no change is effective yet, so current filing obligations continue until there's a final rule. Stay tuned and we'll make sure we bring everybody the latest on this development, which I know a lot of HR professionals will simply say,
oh yeah. Exactly right. Take a breath. And that is a major change.
yes.
And we'll see where that goes over the next 30 days or so, but that's going to be a major change. So stay tuned and we will keep you up to date as we learn more on the EOC reporting.
That's right. The next one, Phil, I'm just going to touch on very lightly just to make sure people are aware of it. Just in the last week or so, the Department of Labor has issued 2 opinion letters on compensable travel/commute time for hybrid and remote-like arrangements. And so there's
All right, so
2.
tell me more. This one will be interesting.
Yeah, so the 2 opinion letters, the first one, FLSA 2026-9, deals with midday travel between an employee's home and work office in a voluntary hybrid setup where work occurs at both locations. Generally, that counts as ordinary, non-compensable commuting time, not worked hours. Okay, so the Department of Labor is taking the position that if you start out your workday at home, you're doing work, and then you leave your home to come into the office in the middle of the day, that is not compensable time. And I think that makes sense. It's just like if you were coming to work at first thing in the morning or when you go home in the evening. If you're moving from your house or you're moving from a location where your hybrid setup is, and then you're going to the office, that is not going to be compensable time.
Do you know, is there a limit, mileage, time, distance, anything like that that complements that? So, for an example, I know many employers have allowed on a voluntary basis people to move out of the state,
Mhm.
right? And move a great distance away. And then when those people may choose to voluntarily travel back into the office or are required to travel back in the office, there's a discussion that occurs, a debate sometimes as to is that compensable or not?
Yeah,
Any insight in that concept?
that's going to fall under the regular rules of analysis that we would use to determine if that is compensable or not, depending on whether
Yeah.
it's done during the workday, et cetera. I think this one is just very clear and very targeted to the hybrid
The
setup.
hybrid setup,
Yes.
yeah, yeah, absolutely. Yeah, but
All right.
good. I feel like that's how it should be anyhow, in my
Yep.
opinion, but not
The
that my
other
opinion
one,
matters here. Yeah.
the other one, FLSA 2026-10, time spent receiving pages, if anybody receives those any longer, calling to schedule appointments and driving from home to a first client appointment is analyzed under those similar principles. That's generally not compensable time. So I just want to make sure that people are aware that those two Department of Labor uh, uh, opinion letters came out. And then I know your favorite topic. I'm going to dig into the third one here. The DC Circuit Court, DC Circuit Court of Appeals on July 21, 2026, uh, citing Looper Bright, our favorite topic, our favorite case we've ever talked about on this
Yep.
program. They cited Looper Bright to strike down what's called the NLRB's successor bar. This one is actually really significant. The circuit panel held that the NLRB board's successor bar rule, and that generally prohibits a successor employer from withdrawing recognition of an incumbent union for 1 year, is inconsistent with the National Labor Relations Act and beyond the board's authority. And so you take this situation would typically arise when a company would purchase another company, and we would go through a whole analysis on whether, depending on the type of purchase, whether you inherit the union or whether you inherit the union and the contract. And I'm not going to get into all of those details, but there is this successor bar that says in a successor company, you cannot withdraw recognition from that incumbent union. And what the court here is saying is that that's an invalid rule. Under Looper Bright, we don't have to defer to the administrative agency, to the National Labor Relations Board, and the board exceeded its authority in promulgating this rule. And so I think that what they might have just done, and I need to look at it in a little bit more detail, but they might have thrown out this entire successor bar doctrine.
Oh, wow.
Yeah,
That would be huge.
it would be
Yeah,
huge.
that would be huge. Yeah.
Yeah.
Now, I do know in many union contracts, and you have a language about successorship, and that might be set aside and separate from that. But it might also be included. I don't know. And that would depend.
It would
Yeah.
depend, exactly.
Yeah.
So that's
Yeah.
where on the clock, all kinds of interesting developments. And that's not
Man,
even
we could
talking
just talk
about,
about those for the next 25 minutes and be just fine. But I do want to get into comp time because it is a topic we haven't discussed before. And I know people work hard to get it right. And sometimes I think, management and HR professionals are really in a tough spot and they find it very difficult to comply because there's usually collaboration on the front side of this. And then things go kind of sideways as we go along and we end up in trouble and for all the wrong reasons and or right reasons, depending on how you're looking at it, things get out of control. So This isn't really as simple as it seems. And many of our listeners practice some sort of comp time right now, for sure. It seems so common, so ordinary, but it's just not that simple. Why is comp time, Bert, such a legal minefield?
Well, I think you alluded to something very important in your lead in there, Phil, and that is that depending on who you are, most times comp time starts out as something good, something the employer is trying to do for the employee, and then ends up in a dispute where it's the old adage of no good deed goes unpunished.
Hmm.
And the reason why it's so complicated is because under the FLSA, the Fair Labor Standards Act, comp time is very heavily regulated. And it's very simple from this perspective. For most private sector employers, comp time is simply unlawful. It is unlawful to substitute uh, time for overtime pay for non-exempt employees. And that's even if both the employer and the employee agree to it. The law simply just does not allow employers to waive employees' right. It doesn't allow employers or employees to agree to waive their overtime rights.
Yeah, no, and that's what I think makes it difficult because people come in and they're like, hey, and here, I'll just throw this one, I'm going to work extra and take off Friday, or if I can work extra this week and I'll come in Saturday and I'll take off next Monday. Can I do that for my vacation benefits or, for medical purposes, a relaxation day, whatever it might be? Why is that a problem?
Yeah, so those informal arrangements, or what I would call maybe banking of hours, or taking a comp day, or leaving early next week, those all can create significant wage and hour violations, just very simply stated.
Okay. Yeah. And what is it that, comp time is legally speaking? Like, what is it? So people are like, well, wait a minute, what is comp time?
So the real definition of it would be comp time would be paid time off provided to an employee instead of paying them their overtime wages. So an example of that would be an employee works 45 hours this week and would normally get 5 hours of overtime, but instead you say, well, I'll give you 5 hours. I will give you 5 hours off next week if I don't have to pay you the overtime this week. And
Hmm.
so the
Yeah.
FLSA does not allow for private sector non-exempt employees to receive comp time in lieu of overtime pay.
Yeah. So, if comp time in the same week and then comp time, calculated in over 2 weeks, we're not talking about pay schedules. We're talking about a work week. So overtime is always calculated per work week, not an average over pay periods. And
That's
that's
right.
one thing that starts to get a little tricky for people. It's like, well, it's all within the same pay period.
Right. So that's one of the biggest misconceptions around comp time is that the Fair Labor Standards Act requires the employer to define what is a work week. And an employer is not supposed to constantly make that a moving target. Most employers will say the work week begins either Sunday at midnight and runs through the following Saturday at 11:59 p.m., or the work week begins at midnight on Monday and runs through 11:59 p.m. the following Sunday. Once you set that, you're supposed to keep that. And so it is not determined over the pay period, it is determined over the work week. So if you're going to use some form of something that you call comp time, make sure you're using it within the same work week. Okay. I would stay away from calling that comp time. If you have somebody who says, you know what, your work week runs from Monday at midnight to 11:59 p.m. the following Sunday, and an employee comes in and says, I really need to take Friday off. I know I don't have any vacation time. Will you let me take Friday off and I'll come in and work on Saturday?
Yeah.
That's not really comp time. you're allowing them in the same work week to substitute what they're doing when they're working. You're just
You're allowing
simply adjusting.
flexibility
Yeah,
of scheduling
that's
different
right.
than comp time.
But if that same employee comes in and they've already worked 45 hours in that week, and they come in and say, "Hey, I've already got 45 hours this week. Why don't you just pay me for 40? I'm going to take tomorrow off, and then give me 5 hours next week that I can take off." Once it crosses over into that second week of that pay period, that is comp time, and that's what's prohibited under the law.
Yeah, yeah. So flexibility is fine, but not retroactive flexibility in that sense.
Right.
Yeah. And
Yeah.
then now in a public employers seem to have a different set of rules. What would be some of the distinction between public and private employers there?
So under section 2070 of the FLSA, public sector employers, would be cities, counties, schools, emergency services, they can legally offer comp time if they meet the specific requirements. And those requirements are, very importantly, prior agreement. You have to have a prior agreement with the people you're offering comp time to, accrual limits, record keeping, and payroll rules. And then very importantly, comp time must accrue at 1.5 hours for every overtime hour worked. So it's not a one-for-one exchange. Even if you're a public employer, you still have to provide comp time at what is effectively an overtime rate.
All right. And that is a common spot where I see sometimes even public employers getting that wrong. They do it in the one for one. And
Right.
again, most of the time I see this happening because people are trying to accommodate flexible schedules
Yep.
and flexibility at work, which is highly important to both employers and employees today. But,
Yeah,
yeah,
of
private
course.
employers clearly just don't get that option. I mean, that's where the line is drawn.
And that's where a lot of companies get tripped up. Yes.
Yeah, exactly. So let's talk about exempt employees for a minute.
Mhm.
So employers often give them flexibility after a heavy work week. Is that considered top comp time?
So again, you have private organizations, private employers that may sort of refer to that as comp time. I think I would stay away from calling it that, just so we don't create any confusion, but that really isn't even comp time. Exempt employees are not entitled to overtime. So giving them flexibility to leave early, or an appreciation day, or some sort of administrative leave, that's all fine. That's flexibility. Uh, what we don't want to do is we don't want to be tracking hour for hour what the salaried exempt employee is doing, and then tying that to specific hours that could call into question the exempt status of that salaried exempt employee.
Right. I
So
think that's a real point of distinction.
yeah,
And it also gets sticky sometimes, just my experience with that is then when people end up leaving the organization and you don't have a quote time policy program, your salary, and you're like, but I have this time banked. They've been counting hours or doing those things. And that's where it often starts to get really tricky.
for sure.
Yeah. So what are let's just talk about the risk with what we're calling comp time, like back wages, liquidated wages, penalties, investigation, attorney fees, people like you want to be paid. Sometimes even class action, like,
Mhm.
what does comp time or why does comp time, let me position it that way, create such a big exposure?
Well, because it's a wage violation, and wage violations, as we've talked about on the program and many of the other programs we've done together, those really multiply quickly. If an employer has been using comp time inappropriately for years, every affected employee may be owed back pay, and not just at a single hourly rate, but at the overtime rate, plus liquidated damages, plus perhaps attorney's fees. And the Department of Labor really does take those cases very seriously. I mean, I don't run across too many employers who officially have a comp time program still in the private sector. Usually it's one of these more informal agreements, as we've talked about before during this program today, that somebody's doing somebody a favor and then later it comes back to haunt them.
Yeah, yeah, and I think to the point you're making, even just calling it comp time versus work week flexibility, scheduling, those something a little bit more creative than what comp time means from a legal perspective, and then what employers try to do also from a legal perspective to be flexible within the work week. It's a little bit better if you can even call it something different and be conditioned that way. But, employees do love the idea of comp time and having that flexibility, family time, recovery, whatever it might be. But not everyone prefers the time off. And that is an important point.
Yeah, there's a lot of employees who rely on overtime wages
Yeah.
for household expenses. Replacing overtime income with future time off can create financial hardship, and that's one of the reasons overtime protections exist.
Yeah. And even if, I just want to emphasize, even if employees agreed to it, that really doesn't matter.
Yeah, I mean, wage and hour rights generally cannot be waived. Again, different in the public sector, as we've talked about today, but in the private sector, wage and hour rights generally cannot be waived. So even if an employee prefers time off, the employer still has the obligation to pay overtime.
Yeah.
40 or more hours in the work week, they're entitled to time and a half, their regular rate of pay for every hour above that.
Yeah. And the second misconception is someone says, well, they're salaried.
Right.
Yeah.
Well, that's right. I mean, salary alone doesn't determine exempt status. Of course, the person, if they are salaried exempt, has to first be paid on a salary basis. But next, they also have to meet one of the duties tests. And so just being salaried does not mean that the person is exempt. They actually have
Correct.
to meet a duties test.
Absolutely. All right, let's just pivot to some solutions. So I think we've covered salaried, we covered private employers, public employers, work week, flexibility, and all these different things that unintentionally create problems when we're trying, and most of the time I think people are trying to do the right thing and help each other out. What are some of the legal ways employers can provide flexibility without violating some of the wage and hour laws?
Well, first and foremost, I would try to stay away from using the term comp time to
Yeah,
describe something that really isn't comp time. Okay, so flexibility is the right way to think about it. All right, so flexible scheduling, if that's going to be done, it has to be done within the same work week. And so we don't want to have if you're going to use flexible scheduling, it can't go from one work week into another work week within that same pay period because that is comp time, which is illegal for private employers. It needs to be done within the same work week. The
yeah,
next would be better labor forecasting. Make sure that you know your labor needs for each week and for each pay period so you don't run into a situation where you're working people too much one week and then being able to provide them time off the following week. It's really important that you forecast that properly. We started off the program during Lawyer on the Clock talking about remote work. Think of remote work options that could allow an employee some of that flexibility without getting into the concept of time off in lieu
yeah,
of working. Um, Flexible start and stop times might be another one, and then discretionary flexibility for salaried exempt employees. Those are some of
yeah.
the top lawful ways to provide flexibility other than comp time, which would be illegal or unlawful.
Yeah, no, that's really good, good guidance there, Bert. I mean, what we're saying is, look, we can achieve flexibility through scheduling and the way that we write our work rules and handbooks and then our practices and so forth. Let's just not do it through what we call comp time and the traditions of crossing work weeks. And I don't want to beat that into the ground, but that's a really big element. And anytime someone's over that 40-hour threshold, then we're obligated by law, and we don't have the ability to just pass and give up our rights that are under the labor law for overtime.
Right.
So, what is it that HR leaders or business leaders should be doing right now when they're hearing this podcast? If they're not really following the program as we would hope they would.
Yeah, the first would be to train supervisors, make sure that HR itself is aware of the impermissibility of comp time for private employers. Uh, Most violations start there from a lack of training. You don't want to have a supervisor sort of agree behind the scenes, yeah, no problem. You've worked a ton this week. We'll give you 5 hours off next week. You just don't
Right.
want that going on behind the scenes. So training is hugely important, and just so happens that's what AIM does best is training, I might add.
Yeah. And these are
Uh,
things we talk about in our training. You're exactly right.
yeah.
Yes.
Audit classifications, make sure that your exempt employees truly are exempt, and that non-exempt employees are non-exempt, and that you are paying them correctly.
And that's
And then,
another emotional one for employers.
yep. And then the Fair Labor Standards Act, I've always said for 30 plus years now, it's one of the few areas of the law that you as the employer are really presumed guilty unless you can prove yourself innocent. And the reason for that is that under the FLSA, employers have an affirmative obligation to keep and maintain accurate time records. And if you don't do that, the burden's going to be the case is going to be construed against you. You have that affirmative burden. That is your strongest defense, is to maintain and keep those accurate time records. So
Yeah.
that's probably the three areas that I would focus on initially.
Yeah. And if an employer is, wanting to implement the comp time policy, what are some of the questions that the business leaders might want to be thinking of as they approach the concept itself?
Sure. The first is, what else can we call it?
Yeah,
Not
yeah,
comp
for
time.
sure. Right.
And maybe that's where the whole idea of flex time has come in.
Yes.
I try to figure out, what are we trying to accomplish here? What are we really trying to figure out? What problem are we trying to solve? And can we administer flexibility consistently? We don't want to create other issues by giving flexibility to one category of employees and not another category of employees, and inadvertently creating some sort of other problem for ourselves, a discrimination problem or something. And could we accomplish through scheduling adjustments the same goal with less risk? So
Yeah.
I think those are probably the top few there.
Yeah, I'm tracking right along with you. I don't know that I would add a lot more to that. When I think about some final takeaways for our audience today, Bert, I know that this it appears simple, but being a practitioner in the past myself, and being someone today, even as a CEO, who wants to help accommodate employees as, they come in and out of the challenges of work life and flexibility that's needed to manage their work life. It can be a little bit of an emotional decision when you have to go, no, I'm sorry, I can't do that because of the law. I wish that I could.
Mm-hmm.
And it's just really a very misunderstood on how, to balance employee expectations with the Fair Labor Standards Act compliance and a sound workforce management. You have to just have your supervisors and managers aligned, because sometimes we're not even aware that it's happening.
For
So
sure.
let's leave our listeners with like three key takeaways. I always like to kind of close the program with that. What would be the three takeaways that you would emphasize before we go?
The biggest one is that comp time is unlawful for private sector non-exempt employees. It is not a substitute for overtime pay for those employees. Second would be flexibility is definitely possible, but you have to make sure that it's done within the same work week, and that training and accurate timekeeping are going to be your best protection against a violation of the law in this respect.
Yeah, and I would add a fourth one that says hours over 40 are paid, and they're paid at time and a half.
Yep. Time and a half, the regular rate of pay. That's right.
Exactly right. All right, Burt, as always, you broke it down. You made it pretty simply complicated for us, and I like that. It's a great legal topic. If anyone needs some professional legal advice, you got pressing issues, I would suggest reaching out to Burt. He's been such a good resource for not just AIM, but for all of our members as well. You can contact him at burton.garland at ogletreedeacons.com. Thank you to our audience for joining another episode at This Week at Work. If you found that you like this and you want to be a part of the discussion, like our YouTube channel, share it with your colleagues. We're here to try and help and serve and make this a better place to work. And your job is to go out and be good to someone. We'll see you next time.